Good morning. The committee will come to order. We always welcome everyone for coming to this hearing today, an oversight hearing on the United States Patent and Trademark Office. And our objective this morning is to review the operations and plans of Patent and Trademark Office under the leadership of Director David Kappos. There are several questions that I think will dominate our discussion today. How is the office performing with respect to the patent examination backlog, and what plans are in place to reduce the backlog going forward? What steps has the office taken and will take to ensure that the United States patents are and remain at the highest quality possible? What are the funding needs of the office, and how can these needs be best met and realistically met? Now, the patent and trademark protection is increasingly important to the U.S. economy. Our studies indicate that intellectual property accounts for as much as 60% of the total United States exports and generates millions of high-paying jobs. So without a doubt, the role of the Patent and Trademark Office is critical to the success of us coming out of the downturn in the economy that we are now experiencing. It's also critical to that success that the office filter out bad patents and trademarks while strengthening deserving patents. So funding, of course, is the key to improving quality and bringing down the backlog. The heart of the matter is that the lack of adequate and dependable funding for the agency has prevented us reducing the backlog, maintaining the high quality of patents approved, and being more generally overall effective. And so, to me, the Patent and Trademark Office needs reliable and sustainable funding, which means that fee-setting authority is important, and that there needs to be an end to the fee diversion that has plagued us across the years. Our chairman emeritus, Jim Sensenbrenner, knows about this firsthand. Even his predecessor, Henry Hyde, worked with us in a bipartisan way on this committee to try to remove the roadblocks. Currently, Lamar Smith and Zoe Lofgren and Howard Berman have all played major roles in trying to grapple with this problem. So the question is how do we do it, and what might we do? Patent and Trademark expects to make between $146 million and $232 million in fees. Some would say this is great, But the problem here is that while the agency runs on user fees, it relies on congressional appropriations to get the fees back. And so far, the Congress hasn't taken any action to ensure that Patent and Trademark receives those unanticipated new fees. Without action, these fees are likely to be diverted as they always have been. And so, to ensure that this organization has access to this funding, I intend that the number of us on the committee work directly with the Appropriations Committee and its chair, the Honorable David Obey, to try to correct this problem that's been going on for so long. Now, to address the longer-term funding challenges, there's been increasing discussion about giving the Patent and Trade Office fee-making authority, as was opposed in the President's 2011 budget. While the current fee structure was meant to encourage the filing of patent applications, the fact that fees are backloaded means the agency may not even have enough money to cover examination costs, and the backlog builds up, and the months turn into years. And I think I'll hear from our witnesses today what that means in the real world. In the past, appropriation bills allowed the Patent and Trademark to use up to $100 million above their appropriation if the agency collected more fees than it planned on. I'd like to make sure that they have such a buffer against diversion in the next budget coming up. And a number of us plan to bring this directly to the attention of our friend Chairman David Obey. Now, the other issue is the reducing patent pendency, how long it takes, and going along with it, increasing quality. I understand that Undersecretary Kappos and Deputy Director Sharon Barner's efforts at increasing quality of patents and in reducing patent pendency is regarded as their number one objective. However, it seems impossible that you're going to, within 10 months, support your goals of 10 months to first action and 20 months to total patent pendency. I think you folks are great, but I don't think you're miracle workers. I've talked to those who say that if everything goes well, it often takes as long as 51 months. And so I doubt that efficiencies can cut patent pendency by half unless we do something far more drastic. And so I support the new examiner count system, giving patent professionals more time to do quality examination. Giving them more time will actually make pendency longer as well. So we need hiring experienced examiners is going, and how will it reduce the backlog? And I think improvements to the system is a big goal, and its necessity should not be delayed. I salute your goals, and we want to help you get there with them. And so I thank you very much, and I'd like now to listen to Lamar Smith, who has worked with us carefully on this matter over the years.
Thank you, Mr. Chairman. Mr. Chairman, as part of the Judiciary Committee's oversight responsibilities, we are here to examine the operations of the United States Patent and Trademark Office, or PTO. Director David Kappos' job is difficult, but he is working hard to reform and modernize the agency. The importance of PTO to inventors, trademark holders, and the American economy is widely acknowledged. Our hearing this morning complements other efforts to pass meaningful patent reform in the 111th Congress. We are working hard with the Senate to develop necessary changes to their bill that will improve patent quality and discourage frivolous lawsuits. I am hopeful about that outcome. That said, the PTO is one of the most important agencies of the federal government, but it's not often regarded as such. Its work affects the productivity and economic growth of our nation, as well as the standard of living for all Americans. For over 200 years, the PTO has been responsible for issuing U.S. patents and trademarks. The PTO also advises the Secretary of Commerce and the President on patent, trademark, and copyright protection, as well as trade-related aspects of intellectual property. In recent years, Congress worked with the Bush administration to provide full funding for PTO operations. Following this trend, the Obama administration recommends that we authorize PTO to collect and spend more than $2.3 billion in the upcoming fiscal year, subject to appropriations. Observers estimate that more than $700 million have been diverted from PTO coffers since 1991, funds that could have been put to good use by the agency. Like you, Mr. Chairman, I support ending this fee diversion. And I support the committee's efforts to provide the agency with more control over its fee schedule and related funding. This doesn't mean we won't exercise necessary oversight as appropriate, but PTO will solve more of its problems if it is able to respond more nimbly to its financial needs as they arise. This change, coupled with our ongoing push to end fee diversion, will position PTO as a first-tier 21st century agency. But if Congress does provide PTO with 100% funding, the agency will have a greater responsibility to explain any of its shortcomings and correct them. Specifically, the committee and PTO must explore the patent application backlog, the state of the agency's IT infrastructure, hiring and retention of patent examiners, the relationships between management and examiners, and the amount of time examiners require to process patents. Mr. Chairman, I'd like to conclude by recounting an event that illustrates the importance of the PTO. This involves Dr. William Thornton, architect of the Capitol, who was appointed by Thomas Jefferson as the first superintendent of the agency. During the War of 1812, British redcoats marched on Washington to burn the city. Thornton realized they would eventually get to the Blodgett Hotel, which housed hundreds of patent models. Hurrying to the scene, he argued to the commanding British officer that burning the hotel and all of its contents would serve no purpose. In an impassioned speech, Thornton said the models were useful to all mankind, not just to Americans. Anyone who burned them would be condemned by future generations, as were the Turks who burned the library at Alexandria. Thornton proved convincing, and the Blodgett Hotel was spared. In fact, it was the only government building not damaged during the attack. Disappointingly, Thornton's reward was a congressional order to vacate the premises. Since the Capitol building had been burned, Congress needed a new meeting place, and the Blodgett was the most suitable venue. Nearly 200 years later, the PTO is no less valuable. Everyone here understands the importance of the patent system to our knowledge-based economy. Mr. Chairman, I look forward to working with the committee and Director Kappos to make the PTO even stronger and more productive and responsive to the needs of the inventor community and our country, so we can enhance our international competitiveness and strengthen our economy. Thank you, Mr. Chairman. Yield back.
Thanks, Lamar, for that little-known piece of American history.
History lesson.
I'd like to invite Mel Watt to make any welcoming or opening remarks that he may share.
Mr. Chairman, I appreciate the offer, and I'm happy to welcome the witnesses, but don't have an opening statement, so I'll pass and
Mr. Chairman.
Await the wonderful wisdom of our panelists.
Mr. Chairman.
Before I recognize Chairman Emeritus Sensenbrenner, let me yield to Zoe Lofgren of California.
Well, thank you, Mr. Chairman, and thank you for having this hearing. I think it's a very important one. As we all know, we have worked on reform of patent law for many years, going back to H.R. 400 in 1995, and these things can get contentious, and I think at this point we have contention once again, and therefore it's especially important that we're having this hearing to focus on what we can agree on, how we can help the office in its pendency problem. You know, although the parties are often sharply divided here in Congress, this is one of those items where we've had marvelous bipartisan communication and effort. It's really been very rewarding to work across the aisle as a team on these issues that are so important to our country. So I'm very interested in hearing from the witnesses about the idea of allowing the office to set its own fees, even on a temporary basis. Let's see how it works, as well as not having enough money, but also having some certainty as to what you're going to have to use and how that would work to bring down the pendency. I wanted to raise another issue as well that I think might have some usefulness in the office. I understand that there's a question or a review of the possibility of field offices that would help in recruiting and also might help in terms of telecommuting as workstations. And I was recently, actually yesterday, in Silicon Valley at home, and I was told that 49% of all the patents issued in the United States come from Silicon Valley. So that might be a good place for a pilot. I know that the representative from the Professional Association will want to make sure that the amenities are good enough. That's exactly the role he should play. But let me tell you that starting at an average of 75-degree temperature in the summer and 65 in the winter, it only gets better from that. So I think members would be happy with the amenities in the Valley, and I'm hopeful that I can work with both the association and the management as we pursue that. It is absolutely essential that we do something on pendency and quality. Our patent examiners are overwhelmed with volume, and that has to affect their productivity. There's no other way around it. So this is very important. I think we'll be able to work together collaboratively to come up with solutions. And Mr. Chairman, I want to commend you for holding this hearing and yield back.
Did I hear in your comments an invitation to Silicon Valley?
Sure. We should review the potential satellite site sometime maybe in August or January, either one.
Thank you. I now turn to the former chairman of this committee, Jim Sensenbrenner, whose experience in this subject is as deep and wide as anybody on the committee, and thank him for all the work he's done on over the years on the subject matter.
Well, thank you very much for the compliment, Mr. Chairman, and let me return it by saying that this is an issue that we all agree on. The enemy is not in this committee. The enemy is in the Appropriations Committee and over on the other side of the Capitol. I spent about 2.5 years during my chairmanship to try to convince the appropriators that what they were doing was really hurting American productivity. And I wasn't able to do that by myself, and I had to enlist the then leadership of the House of Representatives to do that. And we were able to prevent a fee diversion from fiscal years 2005 to fiscal year 2009. However, fiscal 2010 is another story. We may have a fee diversion of as much as $116 million. And this is completely unacceptable because as the economy gets better, we're going to have more patent applications go in, and to take the money away to process those applications promptly is certainly a step backwards. I want to make 2 points. One is that I don't have a problem having the Patent Office set its own fees. But the quid pro quo on that has got to be able to prevent the appropriators from diverting the fees, because if the fees go up and the Patent Office can't use those fees, then we're full speed reverse rather than reverse a step at a time. The other thing that I think this is most important is that with the fee diversion, the Patent Office can't do what it needs to do in order to reduce the backlog and improve the quality. And this committee is hamstrung in being able to do proper oversight over the Patent Office to make sure that the taxpayers' money is being spent properly. Now, if the additional money from fees isn't being used by the Patent Office, then it can't be spent either properly or improperly, and we're stuck in the catch-22 that we're in. So what I would like to say is we're in this together. You need the additional money to be able to cut the backlog. You need the additional money in order to provide the improved quality that is necessary so that a patent is less likely to be attacked should there be litigation on infringement. And, in my opinion, we need to have, a much better attitude nationally, not just here on Capitol Hill, on the importance of patents in terms of preserving our lifestyle, because our lifestyle is dependent upon increased productivity. So, Mr. Kappos, we're from the government and we're here to help, so tell us how.
Thank you, Jim. Judge Hank Johnson.
Thank you, Mr. Chairman. I want to thank you for holding this very important hearing. And for some time now, the USPTO has struggled with timeliness and quality in reviewing patent applications. Currently, there are over 750,000 patents representing inventions and innovation, which are stuck in line at the USPTO, and this number is growing. We have to fix the dependency problem, and I salute Director Kappos for setting an aggressive goal of reducing dependency by half. At the same time, the USPTO has struggled with getting quality right, first by issuing patents on so-called inventions that should never have been granted, and more recently by significantly cutting back on the number of patent applications that are approved. Both these problems, timeliness and quality, have a direct impact on jobs, innovation, and the economy. This is not an esoteric discussion, ladies and gentlemen. This is about getting new drugs, new technologies, and new innovations out into the world. What if there was an invention just sitting on the shelf at the USPTO that could have been used to prevent or ameliorate or clean up oil spills, such as the one that we are suffering from down in the Gulf of Mexico? Another problem underlying the entire system is the agency's information technology infrastructure. Lack of adequate funding for the last several years has put the agency's IT in a precarious position. Its aging systems are crashing and are not meeting the needs of examiners. This is impacting the agency's ability to deal with the backlog and quality problems. Since Director Kappos has taken the helm at USPTO, the agency has announced several new initiatives to address the backlog, patent quality, and the IT infrastructure challenges. I commend him for that effort. I look forward to hearing about the USPTO's new programs, particularly efforts to get to patentability decisions early in the examination process, changes to how examiners are rewarded, and greater use of international partnerships to share patent examination burdens. I'm also interested in hearing about the relationship between these initiatives and the USPTO's funding situation. In particular, the USPTO makes the case that the current fee structure is not capable of meeting the USPTO's needs. That office needs flexibility, in my opinion, to adjust its fees and expenditures according to circumstances that arise. The current economic slump and rebound is a perfect example. In fiscal year 2009, the office fell behind its fee collections due to the economic downturn, and Congress had to step in to protect examiner jobs. In fiscal year 2010, filings rebounded, and revenues have outpaced the USPTO's projections, so Congress will have to step in yet again if the USPTO is to have access to all the funds it collects. Fee-setting authority would no doubt give the USPTO more flexibility, which I support, but I also want to be sure any additional fees go to worthwhile purposes. I hope Director Kappos can explain how the agency plans to use any additional fees collected and how the money spent will address the backlog, patent quality, and IT infrastructure. I also want to remind everyone that Article 1, Section 8 of the Constitution of the United States states that Congress shall have power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. I tell you, those founding fathers were on top of things, and I wonder how they would look at us at this time with the state of our USPTO being challenged as it is today. So I thank you, and I look forward to all of the witnesses' testimonies. Thank you.
Dan Lundgren is a senior member of Judiciary Committee, and we yield to him this time.
Thank you very much, Mr. Chairman. I'm here to listen to our guests, and after hearing both the chairman and the ranking member, I think the issues that I am concerned about have been fully articulated, and I await their hearing.
Steve King, do you want to greet the witnesses or make any opening comments?
Mr. Chairman, I would greet the witnesses and thank you very much. And I'd pass on my opening comment and yield back the balance of my time temporarily. Thank you, Mr. Chairman.
Well, that rarely happens around here. Thank you, sir. Trent Franks, good morning.
Mr. Chairman, I'm just glad to be here.
Okay. Mr. Quigley?
Mr. Chairman, I'm always just glad to be here. I'm anxious to listen to our witnesses.
Well, I'm glad you didn't say that you were glad to be here and hope to be back, but we're always glad to have you here as well. Adam Schiff, could I yield to you at this time?
Thank you, Mr. Chairman. I just wanted to mention that I think the most important part of the patent reform legislation in either house, frankly, will be whatever we can include to deal with the backlog at the Patent Office and make sure the Patent Office has the fees and revenues necessary to eliminate that backlog for all intents and purposes. I think we need to develop a 5-year plan to get that done. We're working on some proposals to help try to structure that and encourage that, that we hope will be part of any legislative effort. And I look forward to hearing what you all have to say today. Thank you, Mr. Chairman.
Thank you. We welcome our witnesses, James Johnson, Damon Mateo, Robert Boudins, and our first witness, David Kappos, Undersecretary of Commerce for Intellectual Property, and Director of the United States Patent and Trademark Office. We'll put your distinguished bio in the record, and you were not responsible for IBM pulling out of this agreement, although you've worked with them in the past. But we welcome you here and know of what you've been doing with this new responsibility that is yours. We met, a few of us met, Lofgren and myself, and met with the Secretary of Commerce and yourself about matters relating to this office, particularly the patent bill that seems to be stalled somewhere between the House and the Senate. But we appreciate what you're doing, and we invite you to make your statement before the committee now. Welcome.
Well, good morning, Mr. Chairman, and I'll start by saying I am very glad to be here, and I do hope to be back. To Chairman Conyers, Ranking Member Smith, members of the committee, thank you for the opportunity to appear here before you today and to discuss the United States Patent and Trademark Office's operations and our various new programs and initiatives. As you know, the USPTO currently faces a number of significant challenges and a difficult budgetary environment. We've made process improvements, and we've made progress in recent months to address a number of these challenges, which I've detailed in my written testimony. Reducing patent pendency and improving patent quality are our top challenges, and America's competitive advantage in the innovation economy depends in very large measure on our ability to meet these challenges. Mr. Chairman, innovation is a principal driver of the U.S. economy. It is an engine of economic growth, and it's a creator of jobs. Promoting innovation, stimulating economic growth, creating high-paying jobs are key priorities of the Obama administration and of the USPTO. We are proud of the role that the USPTO plays in serving America's innovators and providing the intellectual property protection they need to secure investment capital and to bring their products and services to the marketplace. Yet today, we face a huge backlog of patent applications, long pendency rates, and an outdated IT infrastructure. Our ability to effectively address these challenges is limited by our current budgetary constraints, and we've proposed significant changes to our 2011 budget and our budget process. We've developed our FY 2011 budget based on the resources needed to achieve our goals. The good news is that we've begun to see a rebound in user fee collections in recent months, a trend that reflects both an upward-bound economy and success we've had increasing production at the United States Patent and Trademark Office. We currently project that the USPTO will collect between $146 million and $232 million more than its appropriation for FY 2010. Without access to these additional fee collections in FY 2010, we will be unable to achieve our goal of reducing first action pendency to 10 months until 2014. And our goal of 20-month total pendency is now unlikely to be achieved until 2015. While our funding constraints are very real, our new leadership team has developed and implemented a broad array of initiatives to improve the speed, efficiency, and quality of patent processing and improve the overall operations of the office. We've taken steps to improve the examination process by encouraging more interaction between examiners, applicants earlier in the process. We've made the USPTO an employer of choice by offering workplace benefits, including telework opportunities, provided enhanced training of examiners and supervisors to ensure consistency in examination, promoted work-sharing efforts with foreign patent offices to better manage our common workload, and developed customer-friendly initiatives, including our Ombudsman program, Project Exchange, and our Green Tech pilot. These initiatives and the positive results we've seen to date are described in more detail in my written statement. Mr. Chairman, progress toward our strategic goals is dependent on a number of important elements. Among them are providing the agency with authority to set appropriate fees, authorizing an interim fee adjustment on patent fees, and creating an operating reserve to ensure adequate reserves to address multi-year budget plans. As you know, Mr. Chairman, pending patent reform legislation contains a number of provisions that will improve USPTO operations and the patent system in general. Over the last 4 Congresses, the House and the Senate have weighed possible reforms to the patent system. In that time, many of the difficult legal issues related to the intellectual property system have been addressed by the courts. I personally witnessed the House lead much of the discussion around the proposals being considered now in Senate 515 as far back as the year 2000. The USPTO and the administration support your efforts and those of your colleagues in the Senate to enact a fair and balanced bill this Congress, and we will continue to support your efforts going forward. We appreciate your continued support of the USPTO, and we look forward to working closely with you and the members of this committee to meet the challenges before us. Thank you.
Thank you for starting us off. We now turn to Mr. Robert Boudins, who is U.S. Patent and Trademark Office, Department of Commerce, for many years, going back to 1990. He's had a lot to do with the Patent Office Professional Association, has been on the executive committee. This is the employee organization, and we know that you have some issues that you're hoping will be fairly addressed and resolved in the pending legislation. We welcome you here today, sir.
Thank you, sir. Chairman Conyers, Ranking Member Smith, members of the committee. POPA represents more than 6,200 patent professionals at the USPTO, including more than 6,000 patent examiners who determine patentability. When I addressed the Oversight Subcommittee in February 2008, the relationship between the USPTO and its examiners was particularly strained. Attrition was high, morale was low, and the agency and POPA were in the midst of a contentious negotiation over a new collective bargaining agreement. Today, I believe POPA and the USPTO are in the midst of a revolutionary and I hope long-lasting change in our relationship. Under the leadership of Mr. Kappos, the parties have agreed to solve problems through less adversarial and more collaborative and interest-based methods. Since August 2009, the USPTO and POPA have had a joint task force in place led by Deputy Commissioner for Patents Peggy Focarino and myself that has addressed several issues regarding time for examination. Among other things, these count system initiatives provided for the first increase in time since 1976, time for examiner-initiated interviews, realignment of examiner work credit to better reflect when work is done, and an improved award system. In recent months, POPA and USPTO have addressed many other issues, including telework, patent applications on green technologies, and expansion of the first action interview pilot. These and other changes we have worked on together have led to a decrease in attrition and a new level of morale that is noticeable within the examining corps. Allowance rates are starting to go up, while the backlog of applications has gone down. Nevertheless, a number of issues remain of concern to POPA. While the count system initiatives have provided some additional time for examiners, more work needs to be done to address the question of whether examiners in each particular technology have sufficient time to do a quality job. To address this issue, the agency and POPA have been working together with an outside contractor to do a more in-depth study of examination time. POPA has no doubt that the study will show that further increases in time are needed to provide quality work. Obviously, increases in examining time will necessarily require hiring more examiners if the USPTO is to meet the pendency goals of Secretary Locke. Recently, there has been increasing interest in work sharing between the world's patent offices as a means of increasing efficiency. Examiners, however, already use search results performed in other countries, so there is no room for efficiency gains by this approach. To truly increase efficiency and reduce pendency, a work-sharing program must reduce the number of issues an examiner needs to address, and it must do so early in prosecution. POPA believes that work-sharing must be done as soon as an applicant becomes aware of prior art and/or relevant rejections from a first patent office. At that point, the applicant should amend or cancel claims or otherwise constructively address the prior art and rejections from the first patent office in accordance with the laws of the other patent offices in which the applicant has filed a similar application. Thus, the issues facing examiners in those other offices will be reduced, and there will be a real increase in efficiency. Several issues surrounding patent reform continue to concern POPA. We are dismayed that the one-year grace period for inventors and the requirement for examination to be performed by U.S. examiners have both been lost in the proposals developed by the Senate. We encourage this committee to ensure that these provisions are included in any final patent reform legislation. POPA continues to have serious concerns with the proposed post-grant review process. We believe this process will siphon considerable resources away from initial examination while providing little benefit to the intellectual property community. Post-grant review will not decrease the cost of owning a patent. It will only serve to provide one more expensive and time-consuming process that a party may use to protract litigation. With respect to the budget, POPA recognizes that the agency needs agility in adjusting its fees in responding to changing economic conditions. Therefore, POPA supports the creation of a reserve fund that will allow carryover of unused fee income from year to year and limited fee-setting authority for the agency. POPA does not, however, support giving the agency the authority to create new fees or eliminate existing fees with respect to basic filing, search, and examination activities. We believe that the authority to create such new fees or terminate existing fees should remain in the hands of Congress. In addition, the agency's access to its fees should not be obtained at the expense of the oversight responsibilities of Congress. Our experience is that congressional oversight has been very valuable. Finally, since the future of patent reform legislation remains in question, we encourage the committee to consider a standalone bill to address the agency's long-term funding and fee-setting authority. Thank you for this opportunity to present our views.
Thank you very much. We're going to carefully review some of the points that you have emphasized in your presentation. We're grateful that you're here today. Our third witness is Mr. Damon Mateo of the Patent Public Advisory Committee. I'm going to put his biography in the record. He's won more awards in intellectual property than anybody I know of, and also speaks frequently, writes frequently, and has a very extensive management background in intellectual property matters. And we welcome you warmly to the committee today.
Thank you. Good morning. Chairman Conyers, Ranking Member Smith, members of the committee. It's my great pleasure to be here on behalf of the Patent Public Advisory Committee of the United States Patent and Trademark Office, more commonly known as PPAC. Again, my name is Damon Mateo. I'm the chairman of PPAC. I'm particularly grateful for the opportunity because this testimony comes at a pivotal time, one of transitions in the world economy, the innovation ecosystem, the intellectual property landscape, and certainly at the USPTO itself. And now, perhaps more than ever, we find all of these factors linked and essential in achieving economic success. Yet a key link in that chain, the USPTO, is laboring under infrastructure and funding challenges that threaten its progress on many important initiatives. Challenges inevitably...
Pull your mic up a little closer, please.
Oh, certainly. Is that better? Great. But challenges inevitably create opportunity, and ours is to ensure and enhance the U.S. patent system's ability to support U.S. innovation, job creation, and economic success. In order to keep the USPTO the premier intellectual property office in the world, PPAC believes a series of high-level issues need to be addressed and recommends focused efforts and measured objectives for pendency and backlog reduction. As a first step, we understand the USPTO is targeting 10-month pendency to first action on the merits, 20 months total pendency, and also to shrinking the backlog, which currently stands at over 700,000 patent applications. With regard to patent quality, improving the patent process and the product itself, attendant information, search, and work processes is key in providing greater certainty around the timing, scope, and validity of patents. And in support of these initiatives, I'll echo perhaps Mr. Conyers' notions about the budget. Recognizing both the residual impact of the recent economic downturn and constraints imposed by limited financial vehicles at its disposal, PPAC supports the prudent application of several novel mechanisms to help and enhance support the USPTO's operations. The first is to give the USPTO time-delimited administrative fee-setting authority to better accommodate funding needs and also to better align costs and incentives with fees. PPAC suggests setting the bounds of this fee-setting authority, its duration, measurement against agreed metrics for success, the scope of the fees, for example, as a percentage increase, and with possible oversight by Congress and or PPAC. PPAC also supports legislation to permanently end fee diversion and or earmarks, which sideline USPTO revenues that should be directed at its operations, in particular now when the PTO is facing such difficult financial situations. In addition, PPAC encourages the USPTO to expand its modeling of revenue and operational scenarios with an emphasis on identifying priorities as well as contingency planning to support and inform optimal strategy development and tactical execution. PPAC also supports allowing the USPTO to employ more flexible financial tools such as establishing operating reserves. Infrastructure. Extended periods of inadequate funding have left much of the USPTO's IT infrastructure aging, unstable, and barely able to meet the tasks at hand. PPAC sees investment and provision of attendant incremental funding in these IT infrastructure as on the critical path to success for the USPTO realizing many of its key objectives. PPAC also enthusiastically supports the USPTO's recent efforts to totally revisit in a fundamental fashion its IT infrastructure. Process, a common thread that binds many of the USPTO's other initiatives, enhanced process understanding and optimization will figure prominently in the USPTO's ability to realize benefits from many other initiatives and to expanding the work exemplified by the count system, WorkShare, among others. Organizational and hiring. At the core of any organization are its people, culture, and work practices. PPAC encourages the USPTO to continue its outstanding work in hiring, retention, training, to explore new ways to embrace a truly nationwide workforce, and to foster a culture that inspires and rewards performance and initiative. PPAC supports and applauds the broader trajectory of the USPTO, but also encourages vigilance to ensure that visibly articulated goals, such as pendency reduction, are not accomplished at the expense of other PTO objectives or its resources. The USPTO clearly faces many significant challenges, but is also poised to make significant progress against many of them. In our short time together, I've done my best to articulate the challenges, opportunities, and requisites for success from a PPAC perspective. PPAC stands ready to work with the USPTO, with Congress, in support of the U.S. patent system, the innovation economy, and in closing, on behalf of myself and the PPAC, I would like again to express my appreciation for this opportunity to speak with you about these important issues relating to the United States Patent Office. Many thanks.
Attorney James Johnson manages the international enforcement of the trademark and copyrights of many of the most famous and valuable brands. And this includes filing oppositions and lawsuits to protect valuable intellectual property rights. he's also focuses on unfair competition and domain name disputes, and so we're happy to have you here as our final witness, sir.
Good morning, Mr. Chairman and the members of the committee. My name is Jim Johnson. I'm with the Atlanta office of Sutherland, Aspel, and Brennan. I'm here today representing the Trademark Public Advisory Committee. My entire professional life has been committed to trademarks. I started out working in the trademark office as an examiner, then as trademark counsel for Kellogg's, then Coca-Cola, and now with Sutherland, Aspel, and Brennan. I want to thank you for this opportunity to speak with the committee and to share the concerns of the trademark community with the trademark office operations. As you, Mr. Chairman, correctly noted at the beginning of this hearing, the intellectual property protects and promotes the economic engine that that runs this country. And the founding fathers recognized the importance of intellectual property from the very beginning. Our job is to therefore protect and nurture this system so that it can continue to protect and nurture this great economic country. I want to talk about the breach of the fence. As you know, there is a law that prevents the use of trademark dollars for patent matters. Recently, due to the economic crisis, the Patent Office got the authorization to borrow up to $70 million until June 30th, 2010 to use for patent matters. The director has assured us that based on current projections, such borrowing won't be necessary. But our plea to you and plea to the committee from the TPAC is keep the fence intact now and forever. We've had ample discussions on the issue of fee diversions, and we agree and we are pleased to note that the committee supports the view that fee diversion is very bad for the patent and trademark system. A couple other issues I'd like to bring to your attention. One is the unauthorized practice of trademark law before the office. We're hearing anecdotal reports from examiners and from other PTO officials that there are parties that are representing others before the trademark office when they're not authorized to do so. In other words, they're not lawyers. We're in process of assessing how big this situation is, and we'll address it when we figure that out. But potentially the problem is that parties who don't know how to handle applications and things for parties are going to take unnecessary resources from the office. And as Abraham Lincoln said, when you represent yourself, even a lawyer who represents himself will have a fool for a client. We also want to take this opportunity to issue kudos to the trademark operation and the director. The trademark office has performed in an outstanding manner in a very difficult economic environment. They have created a surplus even when filings were down. We also applaud the director's decision to maintain pendency at 2.5 months to 3.5 months from the filing of the application. To put matters in perspective, when I was an examiner, back when there were 13 colonies, it often took a year from the time an application was filed to when an examiner first looked at it. So to be at 2.5 months is a tremendous accomplishment. I don't want to suggest that the office got better once I left, but those are the facts. We also would like to note that the Trademark Manual of Examining Procedure is the manual in which the examiners and the outside public relies, needs to be updated more often and continually. So for the obvious reason that you need a good resource material to review. We've also heard talk about the funding for the new computer system, and that has to occur, and everyone seems to be in agreement on that issue. The Trademark Child Appeal Board is also working well, And the only issues we note there is their manual examining procedure needs to be updated continually, and we understand that they're working towards that. The chairman of the Trademark Trial and Appeal Board needs to be finally appointed. We've had an acting chairman since October of last year, and we need a better structure there. So to whatever you can do to promote that or make that happen, that would be good. And finally, we would note that TPAC needs to be restructured. And we've outlined in detail in written materials what has to happen. But what we have now is the terms aren't aligned properly, so you have gaps in membership. And the chairman of the TPAC comes from outside of the committee, so he has a large transition period. He also doesn't need to be chairman for 3 years because the job as chairman is tremendously demanding. So we need to have a more appropriate succession plan. So thank you again for this opportunity to speak to the committee. We are very pleased with trademark operations. Lynn Beresford and her management staff, Debbie Cohen and Sharon Marsh, have done a tremendous job and under the leadership of Director Kappos. So we're very happy, we're very proud, and we just need a few things to work on. Thank you again.
Thank you all for opening us up to some of the nuance that goes on. Mr. Kappos, can you make Attorney Johnson feel more comfortable about all these people practicing without a license before you? Have you heard about that before?
Yes, I have, Chairman Conyers. Thank you for that question. And as Mr. Johnson pointed out, we're looking into that now. The issue was first raised, in fact, by Trademark Office examiners. And so we're working with the TPAC to look into that issue now and do the fact-finding that we need in order to determine what actions need to be taken.
Mr. Boudins, I noticed nobody else mentioned much about the concerns that you listed. I think it was 5 or 6 of them, maybe. Is there any friendly advice you want to share with your other 3 witnesses this morning while we're all in the room together?
Other than they should always listen to POPA, because we're in the trenches right there. I think some of our concerns are unique to the association because we're internal to the agency. We're dealing with the day-to-day work of the agency. Excuse me. But I think some of our concerns also look to the outside. I don't, for example, our concerns with the post-grant review process proposed in the patent reform legislation. I have a rather simplistic view of it, Mr. Chairman. I don't have the business acumen of my colleagues here on the panel, but it seems in the 20 years that I've been looking at patent examination and patents working their way through the system, it seems that no matter what happens, if a patent, we issue about 150,000 plus patents a year. Only a handful of them ever get into litigation and get real serious. But it seems to me, as I watch patents that are important go through the process, if one party somewhere determines that there's some serious money at stake here, that patent's going to make its way into the courts and through the litigation process one way or the other. And what I see is that when there's serious money at stake, the losing party isn't going to stop, because the patent office said no in a re-exam or says no in a post-grant opposition. They're going to go on to the next level of the appeal process and continue on. So my view of post-grant opposition right now, my concerns with it, is that it will simply interject another level or step of litigation that will prolong the period of uncertainty of that patent, and will increase the expense to the patent holder of maintaining that patent. And I think ultimately in the long term, I'm concerned that will weaken the system and, perhaps make our innovators think of other possibilities or other directions to protect their intellectual property. That's a serious concern that I think we have. I'm also concerned that it will, there's been some talk about being able to accomplish this in a one-year period. I've not seen us actually accomplish too many things in a one-year period before, so I'm a little concerned that will happen. And if it does happen, I'm worried that it will come at the expense of initial examination. And I'm a firm believer that the job we do is important, and we really need to be doing the job right the first time when an examiner picks up the case and do a quality examination and put the strength in the patent, up front. And that, I believe, will in the long term, diminish litigation and create a stronger patent system.
Mr. Mateo, do you think a standalone legislation may be our final resort if we can't really reach agreement? And do you have any hopes or fears about such legislation?
I'm sorry, Chairman Conyers. Do you mean with respect to post-grant opposition?
No, I mean with respect, if we can't work out a patent bill, that we just write a single bill continuing the patent office and giving them the power and the money and the authority that they need to keep going on.
Extension of status quo, in other words. I think my initial reaction to that is once you take the pressure off, you're less likely to get an end result that I think we're all hoping to achieve on a number of fronts, fee diversion, for example. So I would, while it may be an expedient solution, I suspect that having done so would probably, again, relieve the pressure and keep us from ultimately getting where we want to go.
Mm-hmm. Would the gentleman yield? I want to make sure I understand. I didn't understand your comment that it would take the pressure off and fee diversion, because the idea is to end fee diversion with what the chairman is proposing. Did I misunderstand your comment?
No, actually, I believe I must have misunderstood the question.
I
wasn't aware that it was relevant to fee diversion. If the question is, in the absence of being able to pass the patent bill in aggregate, would a standalone bill vis-a-vis fee diversion be something palatable? Then the answer is an unequivocal yes.
Thank you.
Sorry if I misunderstood the question.
David Kappos, what say you?
Well, thank you, Mr. Chairman. So relative to keeping the bill together versus taking up fee setting and other issues, I think that we have a heritage opportunity here on the part of the intellectual property system overall to pass legislation that is generations in the making and it is badly needed. And I think we should take advantage of that opportunity and press on and get comprehensive patent reform done that includes all of the changes needed for the PTO, including fee-setting authority and the others, but also all the other important changes that will move the U.S. patent system back to the gold standard of patent systems and will advantage U.S. innovators for many, many years and hopefully generations to come. So I applaud the work that the House has done, the leadership the House has taken in getting the bill to where it is now. And the administration would like to continue to support the House and the Senate in moving this legislation to completion, comprehensive patent reform legislation.
But we're in a period of we're intransigent now. We seem to be stuck. Someone asked me where we are since we met with you and the secretary, and I said, quite frankly, I don't know. But at least you come to the table optimistic. That's a good sign. But Well, I'll match my optimism with your optimism, but we still are stuck. I don't know what's the holdup.
Would the gentleman yield? And I appreciate my colleagues on the other side of the aisle for indulging me, but are you saying, Mr. Kappos, that if our diligent efforts to do a comprehensive bill fall short, and I've been working on this since 1995 along with the chairman, that no thanks to the fee setting increase, you'd rather not have that? And the end of diversion?
Yeah, my view is that we can get this legislation done.
Yes, but if you're wrong, you're not a legislator. Mr. Conyers has been here a number of decades, and I've learned to respect and admire his legislative savvy. You're saying no thanks to fee authority?
I would like to continue to work with this committee and with both houses of Congress to get complete, comprehensive
we got that
done.
And if that fails, you don't want the ability to set fees. Is that what you're saying?
I truly think it would be preliminary for me to make a comment on that now.
I think that's stunningly disappointing that you'd rather not have the money, but certainly the advocacy groups, the patent holders, and the technology sector feels quite differently.
Well, you tried, Lofgren. We'll now, let's see if Trent Franks can do any better.
Now the chairman's being optimistic. I think all of us understand that one of the great elements of America is this idea of free enterprise and someone launching out to do something that they think can not only serve their fellow human beings but also serve themselves and their families. And I want you to know, as it happens, I'm a patent holder, and so I understand that dream. And I believe that there is a tremendous advantage to our system in that if there's anything that seems to be the product and the outcome of our system, it's this word innovation. And I think it's almost impossible to overemphasize the importance of innovation. I mean, it just in every area of human endeavor, it seems like innovation is a really big deal. And so I like all of you, want to do everything that we can to maintain and protect that process. And it seems like one of the great challenges, Director Kappos, and this is not a criticism, it's just an observation, is that it take the time that a person has to spend gaining the patent through the process application and then, of course, the pending application is one of the big challenges. It's one of the big backlogs, and I would think that, in a sense, that could spell an equation where government is standing in the way of innovation, and that's a significant impact on our economy and our jobs and a great deal of things. It seems to me like that should be one of our number one priorities, is to get rid of the backlog. But there's a concern I have about patent legislation pending in the House. It's H.R. 1260. It seems to me like it could worsen that issue rather than improve it. It could make the process more complex and more cumbersome. In fact, the Manufacturing Alliance for Patent Policy released a study by Dr. Scott Shane of Case Western University. And Dr. Shane found that the House patent bill, according to, this is his opinion, his conclusions, would result in a reduction in U.S. patent value of around $85 billion. Now, again, we'll have to see how time underscores his conclusion. He also concluded that a reduction in the value of U.S. public companies by as much as $225 billion, a reduction in R&D of up to $66 billion, and as many as nearly 300,000 manufacturing jobs would be put at risk. Now, I guess my question to you, Director Kappos, how do you respond to these findings? What's your conclusions, and what specific problems do you have with a House version of the patent reform as it is at this moment?
Okay, well, thank you for that question, Congressman Frank. So I recall having seen that study. It's been months, though, so I'll give you general responses. My view, I completely agree that the backlog is a major, if not the major problem that faces the agency. And every one of those 700,000 plus applications that's sitting in our agency is potentially tens, hundreds, or even thousands, probably in some cases, of jobs that aren't being created, products and services that aren't going on in the marketplace. And so fixing the backlog, if you will, addressing the backlog is clearly job one. I believe that if we can take the backlog from where it is, over 700,000 applications, to its optimal level, which is somewhere a little bit over 300,000 applications, which produces a steady workflow through the agency, we will unleash many new innovations into the U.S. economy. We will improve the U.S. Trade balance because there's so many innovations that come from Americans. We will help put Americans to work. We'll help make Americans more healthy. We'll help save American lives. There's all upside in it. I see absolutely no risk of doing damage to our economy. In fact, we'll do enormous net benefit to our economy.
Well, thank you. Mr. Chairman, I'll just ask one more question, and I'll yield back here. The post-grant review system envisioned in H.R. 1260 is very different than the current vision in the Senate Compromise Bill, S-515. In fact, as I understand it, the differences are so profound that some former opponents of the Patent Reform Bill have now been able to embrace S-515. Since it seems to largely satisfy at least their primary concerns. So, Director Kappos, I'll direct the question to you again. Do you recognize these differences? Can you give us a little analysis of some of those differences? And do you prefer the version now being put forward by Senators Leahy and Sessions over the one that's before the House?
Okay. Well, thank you very much for that question about post-grant. So, yes, there are some differences between Senate 515 and the House version of the legislation. The differences come in several places, including the threshold that it takes to get into a post-grant challenge, the level of later estoppel that is given once a post-grant challenge is completed, some of the time limits that are involved. There are a number of differences. The USPTO, in its technical advisory capacity, is trying to support your team here on the staff on the Judiciary Committee to work with their counterparts in the Senate in order to bridge those gaps and make the compromises that are needed in order to address the issues of parts of the innovation community that still need to be accounted for.
Well, thank you, Mr. Chairman. I guess, Mr. Chairman, I would just suggest that this process, this patent process that is essentially wedded to one of the most unique essences of America, I think is vitally important to our society, and I don't ever want to diminish the incalculable complexity of the job that Director Kappos has to deal with. And I'm hoping that there will be an effort to pull everyone together on this thing, because while I've emphasized the need and the importance of protecting the integrity and the value of patents because of all the reasons I've just stated, I have to believe that there's somehow a way for industry to come together on this one, and it's vital that we do rather than just try to cram a square peg in a round hole, as it were. And so I guess that'd be my thought on it. I understand Mr. Issa has come into the room. It seems he and I are the only two people in the Congress that have patents. He has around 30. I have only 2, but mine are a lot better than his. And so I just wanted to go ahead and leave that on the record and yield back.
Well, that's a modest statement if I ever heard one. Magistrate Hank Johnson.
Mr. Chairman.
Wait, excuse me. Zoe Lofgren, excuse me.
I appreciate for being recognized, Mr. Chairman. I do have to run off and chair the California Democratic delegation meeting, but before I do, I just want to explore 2 quick items. One has to do with the possibility of satellite offices and how that might help. And we had an office that really, it was a virtual office, and it's not really what I think we have in mind on this. And I understand that the Professional Association, disabuse me if I'm wrong, wants to be reassured as to amenities and workspace and the like for patent examiners. And I think that's legit. But I am wondering if, as we move forward, it would be possible to invite the Professional Association or key people out to San Jose to take a look at my district, and I think you'll love what you see. I mean, people love living in San Jose. It's the weather, it's the technology, it's everything, and I think that we could reassure you tremendously if, as we move forward, we were able to do that kind of trip. So is it fair to ask you in public whether you'd be willing to do it?
I have no problems with that, Congresswoman Lofgren. I actually suspect that the concerns of whether people would want to go to a satellite office in San Jose are probably limited. I think we would have very little problem getting people to volunteer to go back west of the Mississippi, including possibly myself. I am from west of the Mississippi.
I would welcome a new constituent.
And so I don't think that's, I actually honestly don't think that's as big a concern. I think more of a concern to us would be, from an association point of view, are they going to have similar office space, similar computer amenities and stuff, and is distance going to affect our IT infrastructure? And frankly, are some of our major concerns are going to be representational? How do we represent somebody foreign, not foreign, but away from Washington, foreign to Washington?
Some in the Valley might say that's good, but
we haven't had to do that before, so for us it's a growing pain.
Right.
I intend to actually, I have intentions of consulting with some of our other labor leaders in commerce who have, nationwide situations to get some of the feels for that. But I think your concern is actually probably not nearly as grave as it needs to be. I think we will probably have little problem finding people willing to go, move back out west.
Thank you very much, and that's good to know, and we'll keep in touch on that. The second question, and I'll throw it out to whoever wants to answer. Obviously, we've been trying to do legislative fixes to various elements of patent law, and as we have, the courts have moved ahead. I mean, with the eBay case, we were told it would be the end of the world if we did anything with injunctive relief, and the world did not end. It's very, it's fascinating. We have the Bilski case coming up, and we don't know what the court is going to decide, but, you listen to the arguments, you have some ideas, and, of course, they could surprise us. It's going to be soon. It's possible, or is it possible, I guess is the question, that Bilski will be clear enough that will make adjudication of patent applications simpler and relieve the burden going forward on the office? Who wants to answer that? Or no one? Mr. Kappos?
Thank you, Congresswoman Lofgren. Without speculating about the Supreme Court's decision in the Bilski case, I think it's quite possible that it could be very helpful to clarifying standards to, for the first time in many years, providing direction to the USPTO and to the entire federal court system underneath the Supreme Court that will enable us to put new, strong, clear guidelines in place for our examiners to do a really solid job of examining patent applications relative to statutory subject matter, and the courts to give us guidance and to take a lot of tension out of what has developed into a state of the law that has become difficult to navigate over time.
Right. Well, Mr. Chairman, I'm going to yield back because of my other obligation, but I want to thank you again for this excellent hearing, and I look forward to working with you, trying to get resources into the office, and I'm sure that'll be a bipartisan effort.
Darrell Issa, top patent holder in the Congress, is recognized.
Thank you, Mr. Chairman. And what would make the gentlelady from San Jose presume that San Diego wouldn't work equally hard and prevail? After all, we do have beach volleyball, better fresh air, stunning views, and a lower cost of living. And, of course, Telecom Gulch is in San Diego. So do what you want. We're united on movement west, but after west, it could be southwest. And may the gentlelady give my regards to our colleagues. Now, on to less serious matters. look, getting a West Coast opportunity for us to get the best and the brightest to help with our side of the problem, to me, is essential. If you're in telecom, if you're in some of the new health sciences, or if you're in, if you will, just high tech in general, now the gentlelady's left, I could say Silicon Valley. I just couldn't say it with her in the room. It's very clear that it's awful hard to get people to move back, particularly if they're in a senior status. They end up commuting, and I see them on the aircraft coming back, working the week in Washington and heading back, or telecommuting. But either way, it's less than it would be if we could have an office. And I think certainly for professionals, if there's a choice between being forced to work out of one's home only or be in Washington, that doesn't really give them the opportunity to work in a collaborative fashion. And this committee has held numerous hearings on the idea of telework. And I would say to Mr. Boudins, you already have a problem of people who are seldom in Washington, that you oversee their well-being. And they do come on our video screens and show us that they're in their flip-flops, and they seem quite comfortable with their basements. So we think we can do that. I have a couple of questions that are only sort of tangentially on task for today, but Mr. Kappos, we don't get you very often, so I'm going to take full advantage. For really into the fourth Congress, I've been trying to get Patent Pilot, as we call it, the Patent Reform Education Act, if you will, through. It's left the House repeatedly. It's died in the Senate with no opposition. It finally found opposition, which apparently it costs money to have judges and clerks be better at prosecuting patents, even though it's only a few $1 million. I want to approach one thing for the PTO. If the training element of providing judges who decide to specialize, or who in fact simply are going to be facing cases, if their ability to get up to speed on patent, both old law and hopefully new law, if within our fee setting of your fees, we were able to set a fee and earmark it that you were able to collect against either new patents or re-exams or all of your other renewals, would that be acceptable to you? And I ask this because, as you know, I've been out to your facility. I realize you have foreign dignitaries coming through all the time for various trainings, and I found it incongruous that we train people from outside the country, but not our own judges to any great extent. Would that be something that you'd be interested if the funds were provided?
Well, thank you for that question, Congressman Issa, and I'll answer it in just a second. I would start by saying, as a California native who was in both San Diego and the Bay Area, as well as Los Angeles.
You know the desirability of San Diego.
That's right. As recently as last week, I can tell you that all three of those areas would be wonderful places to have West Coast operations for the PTO, not the least of which is my home area of the Los Angeles area, in addition to the two that have already been mentioned. Now, relative to the question,
you have a particular part of Los Angeles. We don't want to just say Los Angeles, because that lets you get a pass on too much. Are we talking about the Valley? Are we talking about Simi Valley?
We're talking about Orange County.
Orange County, okay. You know, that's a whole different group. You've now alienated all the Los Angeles downtown. Please.
So, relative to training judges, the USPTO would be very supportive of taking a role in training judges. As you point out, we have a wonderful facility, truly state-of-the-art. We do train a lot of overseas judges as well as patent office officials. We think we can play a valuable role. We do not think that it's extraordinarily expensive. You know, the space is already there and it's already completely outfitted. And without talking about details or dollars, from a principle-based level, I would have no issue with working out a mechanism for funding that kind of training. I think it's absolutely the right thing to do for our country. It's absolutely the right thing to do for our federal judges, magistrates, and all others who are involved in the intellectual property system.
Excellent. The second one is one near and dear to my heart, which is this new problem we have of false marking. as you know, coming out of what is yet not a final decision, but a three-judge panel of the Fed Circuit, we have a broad decision that essentially everyone has standing to claim that a patent is either false marking because it doesn't apply to the product it's on, or that it's expired and thus deceptive. And hundreds of cases have been brought strictly on that one part. I think there's approaching 100 just in the chairman's area of Michigan. You have a specialist in your area, Mr. Chairman. Those cases obviously have a cost. Hundreds of cases have a cost to the court, and yet we have an oddity, and I'd like you to comment on it. That is that the, quote, revenue that might be received by the federal government as a portion of these false marking claims is calculated as a loss if we eliminate those cases, even though it's not yet a final decision. But the cost to the court for having hundreds of cases is not counted. Can you reconcile how we would bring that, just knowing what patent cases are like in the courts? And I know it's outside your jurisdiction a little bit, but maybe you can understand what I can't understand, why there's a PAYGO problem there.
Well, thanks for that question, Congressman Ise. I'd be happy to comment on it, both from my role advising the administration, but also, generally knowing how the industry works. So first of all, there is a cottage industry that has rapidly developed around false marking suits. The last I knew, there were well over 100 filed, all in, of course, federal district courts, to my knowledge anyway. The cost related to those in terms of the administration of justice on the court system is going to be high. You're talking about, federal lawsuits. The cost to the litigants on both sides, but especially the parties who are being sued on this, sort of brand new area of the law, frankly, windfall area of the law, could be expected to be very high. It costs at least in the hundreds of thousands of dollars, if not into the millions of dollars, to defend patent-related suits. And given the possible damages, I would expect that those who are sued would have to mount pretty significant defenses. So the other thing that to me is very speculative right now is the availability of awards, because there's been very little jurisprudence developed in this area, essentially one case that sort of caused this cottage industry to form. So unfortunately, I can't reconcile, how there could be a PAYGO kind of a problem right now. I think there's tremendous speculation occurring in the area of false marking.
Well, the CBO has scored that there could be $4 to $12 million of revenue to the federal government. Could be kind of a guess, but they defend that as well they should, that they were asked to guess, they guessed. 100 cases defended, let's say 50 of them defended vigorously. What would you guess that is to the court, not the litigants, but to the court? Would it be more than $4 to $12 million on balance?
Well, we're both guessing now a bit, but my guess is that it would be somewhere certainly in that range, and that doesn't even count the cost on the side of defending the litigation that is, dead weight drag.
Okay, so we'll assume that our guess on the other side is as good as the CBO's guess. Lastly, I would like you to comment on the real question. I heard earlier the request for fee setting capability, and in the long run, I actually think that we should transition to that. But what if this committee had the legislation and the inclination to allow you to build a true line of credit, not from excesses achieved that were unanticipated, but against revenues that are historically inevitable based on your renewals and other fees? Is there any reason that you could find that wouldn't be the most logical, since we lose money on the applicant and we make money down the road? Wouldn't that be the more I'm leading you, but wouldn't that be the more logical thing for us to do, is to allow you to essentially have a line of credit against revenue that is historically predictable?
Okay, so thank you for that question. and it really goes to having financial tools available for the USPTO to run its operations in a more businesslike and sustainable fashion. And while we haven't asked for a line of credit, it certainly would be something that we'd be happy to work with.
Right, and I use the line of credit. In government, it's not truly that, but it is fee anticipation, I think is the term I've been told to use.
Right. Well, so what we have requested is the ability to form a reserve, because one thing we don't have a problem with at the USPTO right now is collecting revenues. We're actually, as I point out, collecting much more than we have the authorization, the appropriation to use this year. And so if we could have access to those collections, one of the things that we would be doing is forming a reserve, which is sort of the flip side of a line of credit.
Collect and retain.
Right. To be able to use money that we're collecting this year in the future and build up a buffer so that we can operate the USPTO in a more business-like fashion.
Okay, I want to thank you for that answer because, Mr. Chairman, I do believe that in the years that we've worked together on eliminating fee diversion, we really haven't done the second part, which is the fee retention or the fee anticipation. And I do believe that around the appropriators, it is within our jurisdiction to do those two, recognizing that they may still feel that to use it requires them, but to use it versus to have it seem to be two different things. And if we can make sure that they have it, then I suspect that the appropriators will always allow them to use it for good cause. And I thank the chairman yield back.
Thank you, Darrell. Magistrate Hank Johnson.
Thank you, Mr. Chairman. Mr. Kappos, I'm concerned about fees, pendency, quality, all of those kinds of issues, and I'm also concerned about diversity in the workplace. Wanted to, and before I do that, I will say that Mr. Johnson and I, if anyone was concerned or alarmed in any way, we are not related. He's much smarter and good-looking than I, but it's good to have you here, sir. And I'm glad to know that you were a former patent examiner as well. I did not know that.
Trademark examiner. Trademark examiner. I was on the trademark side of the office.
All right, you're on the trademark side. Okay. Kind of right there in the mix, but let me ask Mr. Kappos. I understand that as part of your recruitment program, you've been reaching out to historically black colleges and universities, and I certainly want to applaud you for that. Can you specifically describe those efforts? And in particular, how does the agency reach out to black colleges and universities or colleges that are designated as Hispanic-serving institutions? And also, there still remains some work to be done to increase diversity among top-level staff and management at USPTO. What percentage of your GS 13, 14, and 15 and SCSs, are minorities?
Okay, well, thanks, Congressman Johnson. That's a great question and something that I feel very, very passionately about, and I'll try and answer as many facets as I can. Obviously, the statistics we'll need to supply after the hearing. I don't have those at my fingertips in terms of GS 12s, 13s, et cetera. So we take diversity extremely seriously at the USPTO in all of its forms. We are indeed trying to recruit new examiners, and we're trying to do that with an eye toward diversity. One way to get to universities that have a high proportion of diverse students is simply to go there and speak there, which I have personally done and personally spent time with students trying to encourage them to come and apply for opportunities at the USPTO. Relative to the leadership corps, I agree with you that the leadership corps of the USPTO can be more diverse and needs to be more diverse. And the way you get a leadership corps to be more diverse is pipeline. You've got to go into the people who are being considered for promotion and being developed into the leadership corps. And that's exactly what we're doing at the USPTO, to try and develop a more diverse pipeline for future promotion into leadership at the PTO. The last thing I'd mention is that we actually have a terrific, in general, the agency's got a terrific track record, including being officially recognized as one of the best agencies in the federal government relative to diversity, and actually inaugurating as many as 5 new affinity groups during FY 2010. So just in the time that Deputy Director Barner and I have been at the USPTO, we've made very definitive steps to move diversity to center stage at the USPTO.
Thank you, Director Kappos. In the recent past, there have been some patent examiners who have alleged that there was racial bias by their supervisors in performance evaluations. And of course, that's crucial to this pipeline effort, which I definitely understand is the way to go with creating more diversity in the workplace. What are the procedures that the USPTO uses to address such allegations, and has the USPTO ever identified instances of racial bias?
Okay, well, thank you for that question. We, like other federal agencies, we have an Office of Civil Rights at the USPTO that we charge with investigating issues regarding racial bias and like. We are in the process of recommending or coming into to Congress with some recommended reorganizational initiatives that will include making sure that Office of Civil Rights gains attention at the very top of the USPTO management, and meaning myself and Deputy Director Barner personally taking charge of that office to ensure that any allegations are handled and are investigated in the most careful and appropriate manner. So we take diversity, as I said, very, very seriously. We take allegations of bias of any sort, especially race-based bias, extremely seriously. And we're actually literally in the process of coming into Congress with recommendations to make moves that will strengthen our ability to deal with those matters.
And as I understand it, you're going to be looking at hiring about 1,000 patent examiners over each year for over a 3-year period. And that creates opportunities, significant opportunities to correct any imbalances that may exist with respect to diversity. And that includes African Americans, Latinos, women. It includes Asian and what have you. And so I look forward to seeing the results of your initiatives, which I applaud you for. Mr. Is it Boudins or Buttons? Buttins.
Boudins.
Boudins. Okay, Mr. Boudins. What support services does POPA provide employees who feel that they have been discriminated against.
Thank you.
And after that, I want you to explain to me how patent examiners are rewarded or incentivized. And I guess I'd want to hear from both of you all on that. And also, if you could elaborate on your concerns about the transfer of fee setting power to the agency as opposed to Congress retaining that authority, and whether or not perhaps a sunset provision in any relinquishment of our fee-setting authority to the agency would make you feel more comfortable.
Okay, thank you. That's a handful there. On the first question,
I just didn't want to bog us down too far on the workplace diversity, which of course is very important, but there have been some other issues raised as well.
On your first issue, POPA is the exclusive representative under the Federal Labor Management Statute of patent professionals at the USPTO, both the examiners, and we also have other professionals. We have some librarians, accountants, etc. As the exclusive representative, we have the statutory responsibility of representing all members of our bargaining unit, regardless of race, creed, color, sexual orientation, etc. That's in our Constitution, and it's also required by law. So when someone gets in trouble with management or whatever, they have the right and the opportunity to come to POPA, and we will look into their case, and we will represent them before management if we look at their case and believe that they have a justifiable grievance before the agency. We have a negotiated grievance procedure that covers most aspects of an employee's work life, and we use that fairly aggressively. I'm happy to say that over the course of the last year or so, that we are working together much better. And in fact, I'm happy to say that in the last year, we have not had to taken a single case to arbitration against the agency. And I commend Director Kappos for the fact that we are working much better together in resolving employee issues and coming to resolution to those. But we will handle employee issues, anything that's covered by the Fair Labor, not the Fair Labor, the Federal Labor Management Statute and our grievance procedure, we take a very serious look at. We represent a lot of employees. They have to come to us, for us to be aware of what their issues are. But most of them do, and we try and fix the problems wherever we can.
Well, now, on that point, if you could provide me with some numbers in terms of complaints of racial discrimination and over, say, the last 3 or 4 years, 3 to 5 years, and how those were resolved, I'd greatly appreciate it.
I'll see what I can do. We generally don't keep track of those numbers, and our numbers, I would point out, would not necessarily be reflective of problems at the agency, because the only ones we're going to see are the people who come to us. A lot more people go out the door of the agency than will necessarily come to POPA. Many people, if they get into a conflict with the agency, either choose to just resign and leave the office or go their route. So while I'll see what we can do about looking back at the cases we've handled over the last several years on our grievance side, I would caution you that they're anecdotal and may not necessarily accurately reflect the overall situation at the agency. Okay, I think your second question. Let's see. Your second. You had a question of, you want to know about the awards. We've had an award structure in place for a number of years. that basically was directed at production of the examiners and only awarded examiners at 3 distinct increments, 110%, 120%, and 130% production above their requirements of their performance appraisal plan. Recently, as part of these count system initiatives, we have put in more granularity to that award system and put in awards at 105% and 115, 125, and 135 as a means of trying to put awards within the range of more people. Prior to this change, if somebody was doing 113, 114%, they had no motivation to try and get to 120 if they didn't feel like they could do it, so they could drop back to 110. Now we've by increasing the granularity of the award structure, we're hoping to see more examiners who are at that level, for example, go for the 115% award, even though they might not be able to make 120. And therefore, and by doing so, we're hoping to bring a large number of examiners, maybe a little smaller way, but if we're doing it with a large number of examiners, the productivity of the examining corps is going to go up, and I'm hoping you will see that in a reduction of the backlog. Your third question was on the fee.
Does that have anything to do with quality of the reviews?
There's a quality element in the existing structure right now, where if you have to maintain either commendable or fully successful performance in all the other elements of the performance appraisal plan, which includes quality elements and workflow. So there is a quality built in. We do not have at this time an actual quality award for quality performance as opposed to the productivity award. Happy to consider doing that, as as soon as David and I can have a chance to sit down and talk. The problem we've had in the past with a quality award is determining how you measure the quality. One of the concerns we have is that we need to have an objective standard, for employees, as objective as quality can be, and that's not very objective, unfortunately. But to figure out as objective a standard as we can come up with, so that we don't have a situation where a particular supervisor likes Examiner Kappos and will make sure they have good quality and give them an award, and they don't like Examiner Mateo and don't give them awards. So that's really been one of the problems in trying to create an award system just based on quality. Your third question goes to our concerns about fees. We are all in favor of the agency getting a reserve fund, as Mr. Kappos mentioned. We think that's a great idea, and we should have, we hope you all will find a way to institute it and allow us, when we have carryover money, to put it in a rainy day fund. The concerns we have with the fee setting authority actually evolves from something basically totally separate, and that was, some of you will painfully remember the adventures we had with the rules-making packages for claims and continuations. And the concern really arises out of what I think was a total refusal to listen to the comments of the public when we went through that rulemaking procedure. That rulemaking procedure gained an incredible, had the largest negative response in comments, I think, of any rulemaking package in the history of the PTO. And so where our concern is if the agency was willing to, and I'm not looking at this current administration, but if an administration is in place that would be willing to just look at the rulemaking and just listen to the comments and then ignore them completely, I get real concerned when that turns into some serious money in reference to raising fees and stuff. So while I believe that I want the agency to have fee-setting authority, I want to make sure Congress keeps its fingers in determining what fees are created. Once you all have decided that there should be a fee created for a particular aspect, a statutory process like examination, search, or filing fees, excess claims, stuff like that, then I think the agency, I would like the agency to have fee-setting authority. But I'm leery of having it have fee creation authority. Another problem we saw was in 2005 with the initial attempts to outsource searching. They tried to do that with creating the fee structure that we currently have. We fought that, and thanks to the hard work of at that time, the subcommittee on courts, internet, and intellectual property, we kind of got that circumvented a little bit. But that's another major concern we have. We do want the agency to keep all of its fees and have access to it. That we agree totally with. How we do that, I'm not exactly sure. I don't see an easy answer to it. We don't want to see the Congress, the ability to oversee the agency's actions lost in the process of trying to solve the fee diversion problem. But I wish I had an easy answer, to suggest. I think one of the issues is there a way to get us out from under the scoring process, because I think that is a big headache. But I don't even begin to claim to be an expert on the scoring process. It boggles my brain.
Thank you. Mr. Kappos, anything you want to say about it? And either Mr. Mateo or Mr. Johnson, if you choose to weigh in on any of the issues that I have raised or that have been discussed. With the chairman's consent, I'd like for you to.
Well, thank you, Congressman Johnson. I would just add to what Mr. Boudins has said that I believe our examiners are also highly incented by the ability to contribute, the ability to know that they're doing something important, and to have the time they need in order to do a good job, to do a high-quality job in examining patent applications. And in that regard, I'll read a very brief quote from an email that I received no less recently than last night from an examiner. I get literally hundreds of emails from USPTO examiners, and this particular person, who, by the way, I don't know and have never met, says, "I'm supremely grateful for the work you have done through the revamping of the count system and now through the production goal study." Mr. Boudins mentioned both of those. "The quarter more I get for new cases and the quarter for finals have made the difference between sink or swim. The 2 more hours we received has also been extremely helpful in writing quality office actions." So this is a person who's writing an email not to talk about salary or awards or bonuses or any of that stuff, but to talk about doing a good job. It's really, really important, right? It's a key driver to morale. It's a key driver to retention. It's a key driver to job satisfaction. It's a key driver to everything that makes an effective workforce. It's a key driver to leadership, right? And that's what I'm here to bring. And it's enabling people to know that they're contributing that I think is a major, major incentive to USPTO examiners.
Thank you all.
We now recognize our ranking member who's returned, Lamar Smith.
Thank you, Mr. Chairman. Director Kappos, I have a couple of questions to direct to you. And I was gone for a few minutes, and if you answer these questions, let me know or give me a truncated answer, one or the other. First question is in regard to PTO having fee-making authority. If you did have fee-making authority, what fees would you consider increasing, and by how much? A corollary of that is one proposal has been made that there be a 15% surcharge, 15% increase across the board. If you were to do that or increase the other fees that you might mention now, would that succeed in reducing the backlog in months from, say, 35, 37 to the 20 months goal that you have set for 2014?
Right. Well, thank you for those questions, Ranking Member Smith. So a number of components to how we think that the fees would need to be adjusted. One is short term, and that's the 15% surcharge. And we gave consideration before making that recommendation. We gave consideration to whether it might be better to recommend an interim or short-term adjustment of different levels to different fees. And we decided in the end that it was probably better to make a simple adjustment to all fees of 15% that would enable us to collect money that we need in order to get going immediately on reducing the backlog.
Okay.
So
my questions were a little bit more specific than that. As far as what fees, how much, and would they reduce the backlog and achieve your goal?
Right, okay. So that's the second part of the answer, right?
Okay.
You finish with the 15% surcharge for short term.
Okay.
Longer term.
How long is short term?
Short term is between a year and 18 months. And the reason for that is that even if we had fee setting authority today, we have to go through comment process,
Right.
notice and comment rulemaking, et cetera, et cetera. It takes at least a year to get that done. Okay, so that's why a 15% surcharge short term.
Okay.
Long term. Now, your question, how would we change fees? There are some fees at the USPTO that are just a small fraction of the cost to actually do the work. Reexamination fees, right, as an example. In that part of the office, fees related to appeals also. Those fees are a tiny, tiny fraction. Those fees run into most cases into the few thousands of dollars, and the actual cost to perform the work is in the tens of thousands of dollars. So those fees, I believe, would need to be raised substantially. Other fees we would raise potentially not at all, including some of the fees related to publications, where we want to incent parties to publish or permit the USPTO to
You
publish.
anticipate that those fees that you propose raising would allow you to reduce the backlog to the 20-month goal within 3 or 4 years?
Yes, they will be extremely helpful for us to get there.
Okay, great. My next question goes to something you mentioned briefly in your prepared remarks, and that's the perception survey results from individuals who were teleworking. I've never heard of a perception survey before. It doesn't sound to me like it's particularly credible. When you ask individuals if they enjoy working from their home, you can probably guess the response that you're going to get. My question is this. Are there any metrics available showing whether or not those individuals who telework from their homes or elsewhere actually approve as many patents as those who don't telework? Is there any kind of an evaluation that has been made showing whether those individuals are as productive or possibly more productive or less productive than individuals who don't telework?
Okay, well, thank you for that question, Ranking Member Smith. The answer is there are some factual indications, and I'll tell you about them. I'll give you a couple of examples. One is that we track statistics regarding sick leave, and statistically...
I'm not interested in that. I'm interested in metrics that would show whether those individuals are more productive or less productive. I would expect them, because as I understand it, you are not offered the opportunity to telework till you've worked for PTO for at least 2 years. So these individuals will have more experience than the more junior members. I would expect them to be more productive. And I'm just looking for any kind of a study or evaluation that's been done showing and comparing work productivity with those who telework, or at least the days they telework, compared to those who don't.
Okay, well, I guess I'm a little confused. People who are sick aren't working at all, right? So if we statistically...
Yeah, and I know, my question again, and maybe your answer is there's no such study, and if so, we can discuss whether or not there should be. But I'm interested in metrics that would have been evaluated comparing the productivity of those who telework versus those who don't telework. A part of that might well be more days taken for sick leave versus not, but I'm still looking for the overused word bottom line as far as productivity goes. One way to measure that, it seems to me, would be by the number of patents that are approved. I don't know if that's a legitimate metric or not, but that strikes me as possibly being one. But have any studies or evaluations been conducted getting at that answer?
Right, okay. So the kind of study I think that you're looking for would probably be measuring things like balanced disposals, and we're actually working on that now to take a very cold statistical look at, as you say, allowance or balanced disposals for employees who are on telework versus
So
those who aren't.
that's a study that you've initiated or that is about to begin?
It's about to begin, yeah.
Okay. And when would you feel think that would be completed?
I would say a few months. Speaking generally.
All right. I'd be interested in the results when you get them in. I'd also like to discuss with you before you commence that study if you are interested in discussing the methodology and questions and some of the metrics that might be used.
Sure, we'd be happy to do that.
If that's something that we can discuss sometime after this hearing, I'd appreciate that.
Okay, sure.
Thank you, Director Kappos. Thank you, Mr. Chairman.
You're welcome. Hank Johnson wanted to add one more question to our discussion today.
Yes, thank you, Mr. Chairman. Mr. Boudins, at page 10 of your testimony, first paragraph, it says the proposed manager's amendment to S515 does not contain a provision to maintain the one-year grace period for inventors filing in the U.S. Is that a fact that the manager's amendment in the Senate leaves that provision out?
It's my understanding, unless I missed it somewhere, in the 100 and some pages of that bill, I thought they had moved away from it as they moved towards the first to file process, and they were looking at more of a situation where if I understand the process correctly, where a particular inventor, his prior art or her prior art references could not be used against them by the examiner. However, if somebody else published something in that same one-year period that was along the same, was related or disclosed their invention, through, because they went to a scientific conference or something, that could be used as prior art against them. Whereas I think right now a situation is under 102A that the publications would not be able to be used against the inventor, so that basically the inventors would have that one-year period. And the reason we're concerned about it is because we think, particularly in the academic communities and stuff, there's in America we have a kind of a publish or perish mentality for people in the academic communities, and we want to make sure that they can go to scientific conferences and disclose their discoveries and start working, get the information out to people, or go to different technical meetings and or publish their papers in the science or technical journals, and not find themselves having in a situation where they suddenly have a body of prior art out against them within that one-year period. If I've missed it somewhere in the manager's amendment, I will happily stand corrected.
Well,
but it was a concern that
if you would just simply get back with my office and let us know if you would clarify that statement in your testimony, I'd greatly appreciate it.
Very well.
Thank you. And thank you, Mr. Chairman.
You're more than welcome. My thanks to all of the witnesses. This has been a very informative hearing. I'm going to go through the transcript with my three staffers back here, and then I'm going to take the liberty with the members that participated on the committee, invite you for just an informal discussion about some of the issues that have been raised. And your time and comments have been very valuable. And with that, the hearing is adjourned.